Hi, I'm Natalia and I'm a real estate attorney here in the state of Florida, and today I'm going to talk to you about 3 key things you need to keep in mind when you want to wholesale contracts legally. So a couple things you need to know from the beginning. 475 of the Florida statutes creates a presumption that you are a broker if you are trying to negotiate a transaction between a seller and an end buyer. So you want to overcome that presumption by taking the right legal steps in your wholesaling deals. I always recommend that you have an end buyer in advance. It takes care of so much of this from the very beginning. So always plan your wholesale deals with an end buyer already in place. So here are the 3 things that you need to keep in mind to overcome that presumption that you're a broker. And if you don't have a Florida real estate license, or if you're not an attorney in the state of Florida, then you don't want to get in trouble and do these transactions illegally. You want to do them legally. So here are the 3 things you need to keep in mind. 1, you have to have an equitable interest in the property. So you have to be the buyer that signed onto that contract. You can't be doing this for your neighbor, your friend, your sister, your cousin, etc. You literally have to have put your name under that contract as the buyer. That's where you get that basis of having that equitable interest in the property that gives you that equitable title that you can then assign on to somebody else or market to somebody else. Big thing. 2, you have to have substantial consideration. So in that contract, you can't have put down like $100 as your earnest money deposit in the contract and consider yourself to have substantial consideration. You have to have actual consideration for that contract. Normally, I recommend people put down at least a percentage of the purchase price as that consideration so that you have real value, real skin in the game, because that is what Florida law looks to. Do you have real skin in the game in this contract? Something that really indicates that you have the ability to close on this transaction. Because remember, if you don't have another buyer come into place, you have to be able to close to purchase this from the seller. And then, of course, the number 3 thing that you want to think about is, do you have an assignable contract to begin with? Okay. You are looking to somebody to assign your interest in this particular piece of land in which you have an equitable interest, in which you've placed a deposit. But if you did not do the right thing and make sure that you have an assignable contract, then you are the one that must absolutely 100% close under that contract. So always make sure that you have an assignable contract. Always make sure that that assignable contract releases you from the obligation to close if you do find that end buyer. And if you think of those 3 things, keep those in mind during all of your wholesale deals. You will not get in trouble with 475 of the Florida statutes. Good luck out there, investors.